Welcome to the show where the magic unfolds. Technology and art, a story yet untold. From Lagos to Nairobi, Accra to Johannesburg, we're vibing to the beat. Let the rhythm take control. Oh, tech and art come together, we breaking new ground.
Welcome. This is another episode of the Tech Arts and Soul podcast. My name is Michael Komlo-Opare, and I'm doing this with Ni and
Adwa Painto.
Adwa Painto. You're welcome to the podcast.
Thank you.
Great. Ni, what are we looking forward to for this conversation?
Today we will be talking about intellectual property in the creative sector, and I'm really excited about our guest for today.
Amazing. Adwa,
Yes.
can you tell us a bit about what you do and who you are?
What do? I do law 9 to 5 on weekdays, and then
Okay.
on weekends I'm just a regular auntie. I think that's about it, actually.
Rich auntie.
Aspiring rich auntie.
Aspiring rich auntie.
Yes.
Well, pleased to meet you, and thank you
Nice
so
to
much
meet
for
you.
being here.
It's a pleasure.
So you've been in law for some time now.
Yes.
Okay. Why did you decide to choose intellectual property or that space than maybe corporate law or any other one?
I think my lecturer. It was when I was an undergrad.
Okay.
One of the topics that I loved was intellectual property. It was taught by Dr. Poko Eduse. He's
Okay.
just, I think, been promoted to, or nominated rather, for the Court of Appeal judges. But yes, I loved copyright from then, and I've just stayed in touch. And it also, because I love music and I, to some extent, a creative person, it just makes sense that that's part of the sector, or that sector is where I lean towards.
Okay. I'm curious about what the difference is between intellectual property, patents, and copyright. Can you break it down for me?
So technically, intellectual property is the umbrella term.
Okay.
So that's the broad term. And under intellectual property, you'd have copyrights, you'd have patents, you'd have trademarks, and the like. Now, the main issue is what these different divisions cater for. So copyrights properly so-called caters to the creative process, writing, singing, dancing, computer software. You have patents that are more or usually applicable to drugs, medication, and some people have patents in other things.
Okay.
And the shelf life for patents is generally shorter. Then you have trademarks, which again applies to logos, to marks. So it really depends on what you are seeking to protect.
Okay. All right. Okay. And Adwa, were we making a lot of progress in intellectual property rights before the digital era? And how are we going about it?
I'd say we were. The progress, well, how would I put it? Legislature-wise, yes. In terms of practicability, I firmly believe that Ghana still has some way to go. We have very few case law on copyrights, but I'm seeing more people suing, so hopefully we'll develop that part. But as to the laws that have been developed, we actually we've signed the Berne Convention. We have done the Copyright Act, which is 2006, I believe, Act 690. We are signatories to the Swakopmund Protocol, which talks about folklore and the copyrights that's attached to indigenous communities. So as we're making progress, The issue now for me is the translation or the application of these various laws before the courts, because you can have a set of laws, but really it's the day-to-day activities that shows how it should be applied and in what context it should be applied.
So let's say I'm an aspiring musician, coming up, and I want to produce music that people will love and enjoy. Why should I be so concerned about all these technical, complicated things you're talking about?
You want to avoid losing all your money?
Oh, really?
Yes. I'll give an example. Cisco, one of my favorite artists, he sang Thong Song and Unleashed the Dragon.
That's
God
right.
bless his creative
The
mind.
Dragon is my
Yeah.
favorite.
Exactly.
Yeah.
But he put a lot of work into Thong Song. He actually had an original composition, like classical music, violin composition for Thong Song. So the violin placements you hear, the original pieces, he sought out somebody. He did all that work only to lose most of his royalties because he used the line, living la vida loca. That's one line. Me personally, I believe that he could have stretched it out and won because words are not copyrightable. But they said the interpretation he gave to that one line, living la vida loca, was borrowed from another song. So the writer of that song sued him, and he actually owns the most royalties on the song. So for one, to avoid losing your money and investments, you just want to make sure your bases are covered. And for two, and when you're talking about losing, it's also for licensing people. So that if people use your song, you have grounds to go and say, okay, well, you're using my song for this, or you're using my instrumental for that. I want to be paid. It gives you rights to be paid. So I believe that you need to know these things. And especially if you are signing onto a label or you are writing a song together with somebody, you need to be interested in these things because a lot of times we leave things to chance. Oh, this guy be my buddy. Please, no. Money changes people.
Okay.
Please get involved because sometimes people sign away parts of their rights without realizing that they have signed away that rights. So, for instance, something called your master's rights, ordinarily, it should reverse back to you. So, a lot of big labels will say they have rights to your masters for 20, 50 years. That's how come sometimes you have a song or an artist release an album and it's called remastered because they have gotten back their masters. So now they are, but you'd have all that. And some people, I've seen contracts where people signed over their rights in perpetuity because they did not understand that it is, you can decide not to sign it over in perpetuity. So it's an area that I believe that all creatives, not just musicians, all creatives should be interested in because you need to protect the work that you are putting out for the public.
Okay, so you have outlined the benefits of copywriting. I get that. But once again, at the back of the minds of most aspiring artists is that they want the crowds to enjoy their music. And they are now coming. I mean, I'm now wondering how easy is it to copyright your song? I know like lawyers are not cheap.
Yes,
And affordable.
and in line with that, I would want you to also speak to the Kwesi Arthur ground up situation if you're privy to that.
I think I know a little about that.
Okay.
So the good news about copyright is once you publish a body of work, it's inherently copyrighted. So that's the good news. Okay. The formal registration is so that it's easier, one, to protect your rights. And it's very easy. You just go to the copyright office and pay a fee. It's not any difficult process. You go, oh, I've released this song or I've released this book. This is a copy. I want to copyright it. You can just walk in. It's a very easy process. You would need a lawyer when you are entering contracts and you want advice, which I would always advise that you do. As long as you're entering any venture, get as much advice as you can. If you cannot afford a lawyer, read. Do your research. Make sure that you are being protected. And the Kwesi Arthur issue, I believe it's because his masters are owned by the label.
Okay.
If I'm getting it right, not him. So the issue is, one, if he signed for a contract, it's a contract for a number of years, so he's stuck with them for a number of years until the contract lapses. And then, if I remember, the issue about releasing music and the music belonging to them was because people sign over their rights without realizing sometimes. I haven't cited the contracts they signed, if they signed any, but it's very possible that he signed over the commercial rights to the song. So that's the right to make money or the economic rights. As for the moral rights, which are usually the right to prevent your work from falling into ridicule, the right to be acknowledged as the songwriter, as the song owner, those rights are inherent. You cannot dash them. You cannot give them out, no matter how accommodating or generous you are.
Okay.
The rights that people usually give out are the exploitative ones, the commercial ones. And like I said, a lot of people don't read the contracts they are entering. Sometimes you trust the other person so much, especially in his instance where it looks like it was boys, everybody's now coming up. There's a lot of trust. So you're not thinking that, oh, this is what will happen. And also, something I have come to see is that a lot of people go and download templates. And I'm not saying that you can't. I'm not saying that you can't download templates. But be mindful of which templates you are using. Because some of these templates have very onerous terms, very challenging terms. And once you sign, you are bound by it. And under our laws, unfortunately, it is conclusive. You are conclusively bound by it under the Ghanaian law. So when you are downloading, please be mindful and go over it, because you'd have some templates online which are geared towards the interest of the label alone. Okay. And when it's done that way, it offers very little protection for the artist, because again, the end game of that template is to protect the label or the producer. Yeah. And so you have very little protection. And some people think, oh, we've downloaded it from the site, we are good to go. No, you're not. Like, be sure to read everything. If you don't understand, Google is everybody's best friend nowadays. Google the terms, Google the paragraphs, Google what it means, so that you know that you are making the best possible decision for your career.
Okay.
Interesting. So what I've heard from you is that any musician or any artist out there can, walk into the copyright office and then get their material or body of work or piece of music copyrighted without necessarily having a lawyer with them.
No, yes, you can do that. It's just registrations, a simple registration that you can do. But like I said, I would personally advise you also to get lawyers, not really because of the registration, but so that you are fully aware of all the other aspects of copyright, so that each decision you make, even post-registration, is informed.
Okay. Right. Now let's talk about originality copywriting, because if you are copywriting something, the basic understanding behind that is that you are creating something that you've created, and you want to be the credit for it. How do we determine originality in copywriting?
There are lots of things that go, and the funny thing is, originality is not devoid of influence. So first and foremost, there are some things that cannot be copyrighted.
Okay.
So even if you try copywriting them, it's not original enough. Phrases, slogans, names, words. It's not copyright. You can't copyright it. So I'll give you the artist Pink. Because she wanted to trademark a name, I believe, what she did was, instead of spelling pink the regular way, she used an exclamation mark.
I now understand. I never understood why. Okay.
So that can't be copyrighted because it's not a word. It's a unique placement. So that would be like a trademark in her name.
Right.
But Katy Perry cannot copyright or put a trademark on Katy, because Katy is a name. If she spells it very stylishly, then that she can get protected for the stylish spelling, but not necessarily the name itself. And one of the issues of originality is that there has to be certainty about it. So, for instance, if I compose a song now, there's a certainty to it. It's in an expressed form. You know that this is a melody, and this is what it is. As compared to if I just pick up random names, there's no certainty. It's common. Yeah. It's not unique. It loses that ability to be original. And speaking on originality, you can have originality even when it is built on another person's work. These are called derivative works.
Interesting.
So, say somebody decides to An example of this I would say is Miley Cyrus's Flowers and Bruno Mars's When I Was Your Man. While I wouldn't completely refer to it as a derivative work, is the best example I can think of right now, where everybody who hears her sing, I can buy myself flowers, thinks immediately of, I should have bought you flowers.
Yes,
Yes,
yeah.
it's building on the concept, on the idea, but it's original because it's a completely different tune.
Okay.
Technically speaking, if it's derivative, you have a piece of work, then somebody comes and enhances it so much that it becomes a totally new body of work. So, for instance, those Pimp My Car rides,
Yes.
you have a regular car, then they come, oh, you like fishes, we are putting a whole aquarium in your car.
Okay.
They have added and enhanced the car so much that now it is more than just your regular car.
Okay.
So they can, if that were copyrightable,
Can.
they would have been able to copyright it. So you have that. And I think a lot of people don't know that derivative works also count as fast, because people are always expecting that it should be fresh originality. Okay. And especially within the musical industry, where certain things, chords cannot be copyrighted. So a lot of musical works, in as much as they are original, to some extent, are derivative. Because you are playing the reggae beats. Most reggae songs have one underlying beat under them.
Yeah.
The instrumental or the beat is not what is copyrightable, it's the melodies. Okay. But they are adding on to the general and the genre, the beats for the genre, to make an original song. Same for drill music. Okay. It's literally the same undertones.
Yes, but
you are enhancing it, adding original melodies.
Okay.
But it doesn't take away from the fact that it's drill music. So there's that.
Okay. Now, coming down to our context, there are a lot of African artists that are using platforms to promote their work, and a lot of tech people that are using these platforms to promote their work. How are we dealing with the intellectual property protection for these platforms? So because, for example, let me give an example. So Kim Promise went to Asia and he shut down Asia. TikTok he had much of the traction from these social media platforms. How is his intellectual property being protected?
So a lot of people are, if they are under a label, certain or a recognized label, they would have agreements across the world for royalties. So let's say digital royalties. Once you sign up to Apple, they pay you a percentage of the royalties. That's why Apple Music is not free, because they need to pay the artists for listening to their song. And it's why after a number of, it's minuscule, but that's why people need the streams, because the higher the streams, the more money you're entitled to. So for TikTok, it's a similar thing. So if somebody puts your music on TikTok and you don't like it, you can actually request that it be removed on grounds of copyright infringement if they haven't sought your permission. As with a lot of streaming sites, YouTube, Spotify, you can make those requests. The thing is that a lot of artists also feel that certain covers and sets uploading gives them exposure, so they do not usually raise an issue with it. Some artists do. Emily Sandé, if you cover her song and you haven't sought some form of acknowledgement from her and she sees it, you are very likely to receive a cease and desist. Somebody like Sia would retweet your cover for her to even the Bailey sisters. They will retweet the cover and just be like, oh, okay, yes, she made a cover, I'm flattered. So it really depends. But when you sign on to a streaming service, there's usually a clause that allows them pay you when people stream your music, your work.
Okay. And do you think that these artists are getting fairly compensated?
Fair is relative. For digital streams, it depends. Like I said, Apple is a US based service. It would be more than fair, because look at the city to the dollar. Come on. You don't have like $1 is about 14 CDs now. If you're getting $3 a stream, I don't know the exact amount you get, but let's posit that you're getting about $3 a stream. It's adequate because exchange rate has shown all of us that we are not the dollar smiths. But you are looking at something like the Zimbabwean dollar. In that situation, the amounts may be the same, but is it fair? Yeah. So we have a principle in law that it's not really the fairness of the compensation, in as much as it's it should just be sufficient. So it doesn't have to be adequate. So if I want to sell you my house and I want to sell it for 1 cedi, is it sufficient? Hey, is it adequate? No, it's not adequate, but is it sufficient to appease me? Yes. So that is it. And it's usually, like I said, because it's based on streaming numbers. Okay. The issue is how to get their numbers up because the rate is fixed to some extent. As you go higher, then your bandwidth keeps increasing.
So for, let's say for tech people, how are we able to identify intellectual property within the work we do and apply for a protection for that?
Okay, so software is copyrightable. Computer software and programs are copyrightable. A lot of people don't know that, but you can actually and absolutely register for copyright protection for software, for programs. You can absolutely do that. And like I said, sometimes it also applies to the finished work. So if you're putting out a book, if you're putting out an app, you can get copyright protection for all these things. If you're putting out a song or even AI, well, digital arts, not AI arts, but digital arts. Okay. All these are forms of expression, creative expression that have been put in a tangible form. You can get all of that protected. Okay. The issue is not whether or not you get whether or not you can get it protected, in as much as do you know that it can be protected. That is where the real battle is.
Okay. Can I copyright a piece of work I created with AI?
I was coming to the AI conversation, so
AI is fairly new, and there are lots of gray areas with AI. So it depends on the level of AI you are using.
Oh, I've produced a banger with AI. It's a good music. You love it.
Is it the percussion set? Is it the piano? Is it the voice overs? Like, is it because if you deep, it's even auto-tuned to some extent is AI, but it's just a very basic form. So the issue is in what capacity are you using it? And like I said, it's a gray area. So whilst you can register it as your own, the gray area comes if you're using somebody's voice and likeness. We don't yet have any proper laws. We might argue that it's unethical to make money off somebody's voice and likeness without their consent or permission. But no, we are still yet figuring out the ins and outs of regulating AI within the general space, much less the creative space as well. So I believe that with time, we will find laws. One typical example is when cryptocurrency came. I mean, we are still finding laws, but when cryptocurrency came, we didn't have a lot of laws that dealt with it. Now, almost every country is doing some form of laws. Ghana passed the Payments Systems and Services Act in 2019 to at least, it doesn't cover the entire scope of fintech, but it covers some parts. So as we go further, laws will definitely come. There's a saying that law follows development. So the law will follow the development. As we move further with the advancement of AI, people would see the need and be able to determine which areas need regulation and which areas should just remain gray.
Okay. But who would be owning the revenue, or who would be receiving the revenue?
That's the gray area, because the copyrights, the software, the creator of the software owns the copyrights in the software. So you pay for the use of the software. Now you come to you using the software for your music. You own the copyrights in your songs. The issue is, since you don't own the copyrights in the software, what happens? But looking at practice and what has been happening, I don't think that should be much of a problem. I believe that what will happen is whatever work you create would be within the copyright of the creator, not necessarily the software holder. So, for instance, when we look at labels and we look at all these mixing machines, all these beats creating softwares and all that people use, and they pay an annual license to use.
Yeah.
When they are done creating, mixing, they own the work. As practice will have it. When Kanye finishes his songs, he owns his work. He's not sharing, apart from his label and his other issues, he's not sharing it with the beats maker.
Okay.
The software developer for the beats maker or whatever app he's using, because he's paying an annual subscription fee for that. Okay. So looking at the practice, it is very likely that it would go the same way. Once you pay for the use of the AI, whatever you make out of whatever AI software you are using becomes your property. That's, again, for me, it's looking at the trend that we have set so far. But it is very possible that it may change because, again, we are developing AI is becoming capable of so much more. And so there will be a time where we need to further regulate the use of AI within the creative space.
Okay. And
Okay. You have a follow-up question?
I actually wanted to, I think she's spoken to it. I was thinking about asking how the revenue would be shared, but I think she's maintained that it would go that way where the AI owner or the software owner would be paid, and then also whoever created the work can take the
At
proceeds
least
of.
from what we are saying right now as to practice and the use of software in making music, there's a fair chance that that's what would continue.
So, right, in practice, we are seeing a lot of artists in Ghana, putting their music on social media platforms for their fans to download and then enjoy. They are not putting it behind paywalls like Apple Music and the rest. Pay like, what's your opinion on that?
It's up to the person. Some people do not want to monetize their music per se. They just want to release music because I like music. I want to release music.
Okay.
And like at the end of the day, it comes down to the person or the artist. If I want to put my music on Twitter, Instagram, just for people to listen and enjoy, and just so that I get my fame or I get known, I become known. That is it. I'm not at that moment concerned about making money. And as I said earlier, some people look beyond that. So, like I said, if you see a YouTube cover or covers of a particular song so many times, it's very possible that the artist knows and they are like, okay, you can make covers. You're not going after you. Yeah. But for some people, they will absolutely come after you and it will be removed. It will be removed. But for some artists, especially the common ones, they themselves would even come and look for you to some extent. If they think that you made a good enough cover of it, they will come and look for you and say, okay, I want you on my team. Or they would even retweet. I think somewhere early this year, when Tyler, the South African musician, was blowing up, she posted about how she used to post YouTube covers of her singing when she was younger. And Boyz II Men, one of the Boyz II Men members, reposted one of her old covers because she was singing a Boyz II Men song. And you can tell that he's cool with people making covers of his songs. For that band, they don't seem to care whether or not you come and ask for permission. Because technically, before you make a cover, you need permission. But there are some people that we have come to see within the industry who wouldn't mind people making covers of their song unless they are going to technically release it under an album or something. But if it's just, I'm making a cover, I love the music, I want to sing, they don't mind. Like this Boyz II Men situation, he came to post it on Twitter and said, yes, she's not lying. He clearly didn't mind. So it really depends on the artist, and which brings us to the point of studying who to cover so that you do not fall. Because for some people,
will you know?
You wouldn't know for sure. It's always a risk. But like I said, some artists have generally shown that they don't seem to care. If I wanted to cover a Beyonce song, she wouldn't mind. She's not sending cease and desist to people, poor people. She doesn't mind. And if it's good enough, it will feature some way. Yeah. She will mention you somehow. And we know that she sees what is on the internet.
Okay.
She won't mind. Adele, if you do covers for a song and she sees it and you go and stand at her show, oh my goodness, she used to make covers on my show back in the day.
Yeah.
So you learn, and the more popular the covers of the song, the more likely it is that the artists or the labels do not mind people making
Covers.
because there's a saying that imitation is the greatest form of flattery.
Okay.
And it's opening up these people also to a wide range.
Yeah, so
of,
kind of they are tapping into the communities of these people that
Yes.
run the covers as well.
It's opening you to more people. You are getting more
Streams, more,
Streams,
traction,
more listeners, 'cause
redirections to the
redirections, yes.
original work.
something happened recently. Tracy Chapman. I talk a lot of foreign music. Oh, Rade. Instead of
Don't worry. After this example, I'll come to you.
to be fair, I grew up on Tracy Chapman. Okay,
Sure.
my mother loved Tracy Chapman and Whitney Houston, so that is what I grew up on. But Tracy Chapman's Fast Car gained popularity because of this white person. I can't remember his name. Is it Lucombe? I don't know. Or Teddy Swim. I can't remember the person's name. But Fast Car, which is one of my favorites, wasn't known. A lot of people didn't know Fast Car. A lot of people know I'm Sorry. Can I hold you, baby? Can I hold you tonight? But a lot of people don't know other Tracy Chapman songs. It looked like she had died, and he opened her up to an entirely new fan base by just covering Fast Car.
Right.
So for Tracy Chapman hadn't performed in forever,
Yeah.
and all of a sudden she was performing for the Grammys last year,
Yeah,
I believe.
yeah.
She came to perform Fast Car.
Yes, yeah.
So, you can tell that she was chill. She didn't really mind him making a cover of her. So, with time, you get to see that some artists and some labels don't matter because to them, it's a form of enlarging their fan base.
Yeah.
Some people also feel like it matters because even if you're enlarging my fan base, my music is mine.
Right. So you sing, and I've come across a couple of renditions on your social media. Why are you not putting your songs or your renditions behind the paywall? You're putting it free of charge out there. Why are you not copyrighting them?
One, I'm singing because I like to sing. I'm not really singing to make money. And so technically, if I would now want to put them behind a paywall, I would have to seek permission from all these other people to put them behind a paywall, at least write to the label, inform them and all that. And personally, it's a lot of work for me. But also, I'm singing just because I like to sing.
Okay, so let's look at a scenario like that. I mean, you've started singing recreationally. Then after some time, you decided to take it professional. And someone is able to identify you based on previously what you've done. And then you become a superstar one day. If, let's say, you use some of my songs in your previous renditions, now that you are a superstar earning millions of dollars, can I come after you to say that, look, you're sampling some of my music and I'm entitled to some royalties?
If you say sampling, that is a different conversation because sampling, interpolation, you need, and I would always argue for this, express consent. Get that consent in writing, whether it's by email, whether it's by WhatsApp, whatever way, whether it's by a letter, get that consent in written form, in a form that you can prove. Once it's sampling and interpolation. Once it's covers, it depends. Like I said, some people don't mind. Tyler has blown up. Boys to Men are just glad that they were part of her journey. They don't mind that she used to make all these covers.
Right.
And the issue is, now, what are you making the money off now? If the money you're making off now is your original compositions, then you can't claim it because back then it was recreational, for lack of a better word. And another thing a lot of people don't realize is sometimes people join collective societies. And these collective societies are supposed to pay other people and also give you the right to use their music. So, for instance, if I joined Gamro and I was paying my Gamro dues regularly, by my membership of Gamro, I would have the license or the rights to use other members' songs or other members of Gamro songs. So, if let's say Kwame Mickey is in Gamro, I can use that because what Gamro has done is to be the bridge between me and Kwame by making sure that he is paid royalties for the use of his song.
Okay.
So permissions that you would require, you are seeking them out from him. and you are paying Gamro your dues, it is from your dues or from the other application fees. So if let's say you are registering with Gamro, you say, I want to make a cover. They say pay XY amounts to make a cover of this song. And you make that cover. Then you are protected because you have sought the permission by reason of being in that space and by reason of paying the applicable fees. So if Kwame would have an issue, then he now has to go and accost Gamro because Gamro is like the middleman, the agents between the two of us. Okay. So it depends. And a lot of these little artists or upcoming artists are part of collective societies, which is why they can do certain renditions because it's just a larger body. And so they are paying their dues technically to you.
Okay.
You've sold Gamro just now.
Not really. It's just so that people know how collective
absolutely, because I mean,
work.
In my understanding, I don't know about our audience or about Michael, but you have explained Gamro in a manner that I've never thought of. I've never seen Gamro in that light.
I've never seen them in that light.
Like,
because I've always felt like there were some body that just wanted to bring everybody under the umbrella just to take their dues. Like I really did not understand
musicians get
or know what exactly they were doing for.
It's why the musicians are fighting them because some of the royalties are low.
Okay.
that is, and sometimes they make decisions that people do not agree with. Again, it's a group of humans. But the funny thing is you could actually absolutely have more than one collective right society, but because they need permission from the AG's department, the ministry, it's a little more complicated. So to form a collective society, you need to apply for a license. A license is valid for, I believe, 5 years. The last time Gamro had issues was because they hadn't renewed their license. I don't know if they've renewed it now. Okay. But your license is not in perpetuity.
I see.
You have to be renewing it.
How long does it take to settle a copyright case?
Oh, it depends.
And I'd love you to speak to a personal experience where you had to, where someone's data was breached or someone's IP was taken and you had to fight for it.
I wouldn't say I fought for anybody's. I don't think I've completed any case. Let me put it that way. Completed any case where people's copyrights were being infringed. We are still in court for that. And it depends because the wheels of justice grind slowly, as they will say. But it depends.
2 years.
You can use as little as 1 year. You can use as much as 3-4 years. It really depends on the facts of your case and your opponents. And of course, the little issues in the justice system, say they change the judges 3 times, and nobody has control over that. So that would just lengthen your case. Or in those little holidays, there was a time when the last Eid, everybody thought it would fall on a Wednesday. So me, in my usual fashion, I didn't take any cases for Wednesday because in my head, Eid is going to fall on a Wednesday. And I booked all my cases for Thursday. And then Ministry of Interior decides the holiday would be on a Thursday. So I work on Wednesday, which is good because I don't have court. I can focus on the other aspects of my job. But now I'm like, okay, Thursday, we have to reschedule all these cases. And judges have full diaries. Because they are not only looking at your cases, and all these are little delays that come. So you can't say, by 6 months we should be done, because it's a human institution, and things happen. But the one case I remember was a copyright case. It was a film case. Justice Tanko was presiding over that case, and I'm not sure if he's promoted, but he was in the Court of Appeal.
Is it okay to talk about it?
Yes. It's in public domain. So judgments are public domain.
Okay.
So once judgment has been delivered.
Okay.
And I wasn't involved in that. Was when I was still, a student of the law. So this is a while back, and I was in the Court of Appeal. We were observing cases as part of our internship program, and it was about a Nigerian movie that was being pirated in Ghana.
Wow.
So he had come all the way from Nigeria to get an injunction, or how do I explain an injunction? It's legal way of saying restrain, stop these people from doing that. Okay. Just basically legal talk to say please stop them. Yeah. So he had come for an injunction because it is his copyright that is being breached. Somebody has sat down, written plots, cast actors, directed movie. You are coming to pirate it in Ghana.
Yeah.
Oh, no, not on his watch. And he actually succeeded in his claim.
Wow.
And that was the last, and let's not, yes. Another one that my firm did, I wasn't involved.
Okay.
It's involved DVLA, and I don't know if those artists, his stage moniker, but basically what happened was DVLA was using parts of his song in one of their public campaigns.
Ouch.
And they hadn't contacted him. They hadn't written to him. They hadn't informed him. So he's there, and then he just hears, my song is being used for this campaign. So he sued, and he won. Because they should have sought his permission.
Yes.
They should have said, we want to use, because they wanted to argue that it was public education. But the government, one of the reasons the government gave was, the judge gave was, you can argue that, but you are still commercializing it because whatever campaign you were doing was to raise revenue
Yes.
for DVLA.
Yes.
So to some extent, you are receiving commercial benefits from it.
yes.
And once you are exploiting somebody's copyright commercially, you need to pay the person. So they paid him, and I think this must have been in 2016 or 2018. I don't know. It was one of the teens. That's all I can remember.
Okay.
It was one of the teens, late teens. But yes,
Okay.
we need more people suing on grounds of copyright so we can develop it, because the cases are few and far between.
Okay.
Very few and far between. And I believe that for the development of law, people should just sue for shaggy reasons. Your money would go, but, develop the law. You will help us develop the law. Your progeny would thank you.
But is this also to mean that if government is to pick a copyrighted piece of music for public education, just that, no commercial interest anywhere, is that allowable under the law?
Depends. You would need the person's permission, one, because sometimes it depends on what you're going to subject the work to. And there's a concept known as moral rights, which gives creators the right to decide what they want their work subjected to. So even if you're not exploiting it and you are using it, but you're not acknowledging that I am the owner of the song, you are using it in a very vulgar manner. I have the right to come to you and say stop, and to sue you to stop because it's infringing on the integrity of my work. So I would say that you do need the consent, because there are apart from commercial rights that accrue to a creative work, there are moral rights that accrue to it as well. And unfortunately, moral rights are non-negotiable. They stay with you till you die. So for that alone, yes. But we have something called fair use and permitted use in copyright. I believe that's section 19, which allows you use copyright on and off. So sometimes for certain broadcasts and all, but for the avoidance of doubt, because the language around it is very technical, and which is not anyone's fault, it's just legalese. For the avoidance of doubt, I would say that anytime you are seeking to use anybody's work, always reach out in writing. Please let there be a record to the person and say that we are doing this with your work.
Okay.
Are you okay with us doing this with your work? If they will charge, let them charge. If not, that is fine.
Okay. What are some recommendations for creatives and tech creators? What are your recommendations for people so that they can protect their intellectual property going forward?
Read.
The fine print.
Read the fine print. Read the fine print. Read the laws. And maybe for creatives, you can make an excuse. But for tech creatives, there is no excuse. I have seen the papers you people read. You do not have an excuse to say law is technical. No. Because I did a fintech. I co-wrote an article with my professor on fintech. And the papers I had to read, you cannot convince me that tech bros find the law difficult. You cannot convince me. Mm-mm. So tech bros and tech girlies, please read. Creatives, we can cut them slack because, they're coming up. But tech bros and girlies, no slack at all. But read the fine prints, read the laws. Google, if you are not sure what it means, what does this mean? You can sometimes even copy and paste the whole thing. It would help you understand. Speak to people. Attend seminars. There have been, since 2018, there have been at least 2 copyright and intellectual property seminars that I have been a part of. And on both occasions, you could count the number of actual creatives in the room. And this is this doesn't count the other ones that people do. Okay. I have a colleague in the field, Antoinette Boama, one of my favorite lawyers. In fact, she's, people say if you're a lawyer, you don't need a lawyer. Yeah. She's my lawyer.
Okay.
Also known as If You Are Blue.
Also known as If You Are Blue.
Oh, okay.
Great.
Okay.
Great.
Okay.
Wonderful lawyer, wonderful person, very deeply invested in entertainment law.
Okay.
She has organized seminars, been part of seminars, and she will also tell you that people don't come. We are organizing all these freebies for you because we love you. If you loves money, like me, money makes your life easy. And people don't come. And sometimes you find little bits of legal advice because it permeates everybody's life. Yeah. So sometimes you see that she would post something and say, please do not sign certain kinds of contracts. Yeah. And people will just think that, it's for, laughs and giggles.
Yeah.
But these are the little things that you need to be conscientious about as a creative so that you know how to protect yourself. And also, please be ready to pay your lawyers because sometimes you're not even charging or asking for much. And the money you will expend in correcting your mistake is always more than the money you expend in preventing the mistake. Okay. If you go to Ifya and she says, or you come to me and I say pay 4K to draft a contract.
As in 4K Ghana cedis or 4K USD?
Let's say Ghana cedis because now
says underground artist.
It's an example.
Okay.
No, I want you to qualify
you can pay in installments. People do payments in installments.
Okay.
20 cities.
No, if you do Momo, don't tax me, please. E-levy. Thank you. Please. But
Bamia's digital agenda is
But, okay, pay for your service because that 4K you pay would be comparatively cheaper than if you go and sign some very bizarre contracts and you have to pay. Now you're paying filing fees, you're paying lawyers' professional fees, you're paying statutory and allied fees. And then on top of that, you're wasting your time to come to court every God knows when. And our court system, even though it's improved and it's better because we are trying to be fast and promote expediency, things happen. They promote people to the Supreme Court. They promote people to the Court of Appeal. It's not because of your case that somebody will be stagnant in their career. Okay. People fall sick. People die. Holidays happen. Like what happened to me. Yeah. Puts all my cases on a Thursday, only for the holiday to fall on a Thursday.
Okay.
You will expend so much more time and money in fixing that mistake
issue than
in just paying upfront to prevent that mistake.
Okay. What are some future trends that you anticipate in terms of intellectual property rights?
Future trends. Well, there's a saying that nothing is new under the sun.
And especially also with AI.
But with AI, I see people making a case for the extension of moral rights, as I've been saying, particularly with the likeness of people's faces, voices, and people's mannerisms. Because we have a thing called passing off, even though it applies to goods and products. Okay. So if I have Pepsi Cola and I decide to do Pepsi Cola with a B, but I don't make it very clear, it is a case of passing off because people will see that and just assume that it's Pepsi Cola. And once that exists, I can see that people will just transfer that thought or that school of thought towards the AI when it comes to mimicking people's voices, because now you see a lot of, which you see in the very recent Drake-Kendrick beef, two grown men fighting. Anyway, I'm not a rap fan. But I listen to rap, but I'm not a fan.
Okay.
No problem. That's your wala.
But the estate of Tupac actually asked him to pull down Tupac's likeness and the voice he used in the AI. I think Snoop's label also reached out to him and told him that please take it off. So I can't remember which of his disses it was, because at this point they are making so many diss tracks you can't even keep up. Like it used to be just one. You drop one, I drop one, we go. Now people are dropping disses in multiples. What is happening? We're losing recipes. But they asked him to pull it down.
Okay.
And so he did. And I'm anticipating that would be a big step moving forward, because there's been a lot of AI generated voiceovers and covers of popular songs in the past year. And looking at how the estate of Tupac and how Snoop Dogg's management handled the Drake issue, I foresee people moving in that direction.
Okay. Okay, Ni, it's been an insightful conversation. What has been your takeaways from this?
I am worried that it can take between 1 to 4 years, to settle the copyright case in our courts.
And maybe more.
Maybe more. And I'm really, really worried, because it will be a great disincentive to a lot of artists, because it's not just about going to court, but there is also a lot of money involved in the process. And I'm also coming to understand the relevance of streaming platforms, because, and Adjo, correct me if I'm wrong, if I put my music on Spotify, on Apple Music and other paywalls, and people stream, I think all these platforms take care of this copyright
to some extent,
and even limit people using my material to put it on those platforms, because they do all those checks there for me. So I think that will be a far more easy and stress-free option, than going to court for 4 years. Okay. And I get that. And I also love the clarity that she brought to the discussion regarding the copyright process. I was thinking, to do a copyright, maybe you have to see lawyers, pay some fees, ask for their express guidance throughout the process. But like she said, if you read and you understand what you're about, you can walk into the copyright office yourself and get the process done. And that's an important piece of information that you go out there.
We have been discussing intellectual property, tech, and the creative sector on today's episode of the Tech, Arts, and Soul podcast. If you're a creator out there, of course, remember to read, and make sure that you get the fine prints correct. My name is Michael Komlo-Pare. Shouts to the crew, director, Efo. Subscribe, like, leave us a review, and more importantly, share within your community. Thank you, and catch you on another episode. Bye-bye.